As we come on the air, we are on the lookout for special counsel Jack Smith to respond on the question of presidential immunity that is now before the Supreme Court. As the New York Times puts it, quote, respond to Mr. Trump's emergency application asking the justices to halt the D.C. Circuit Court ruling that rejected his claim that he is absolutely immune from criminal charges. It was only 24 hours ago the disgraced, twice impeached, 4 times indicted ex-president filed his application to the Supreme Court on presidential immunity, a filing that, like Donald Trump himself, was equal parts brazen and cringy. From the opening salvo that inexplicably quotes Yogi Berra, the baseball great infamous for his verbal gaffes, to Trump saying he wants the case paused pending both an en banc review by the whole D.C. Circuit Court and a review by the Supreme Court, a legal have your cake and eat it too, that the D.C. Circuit Court specifically discouraged Trump from asking for. Earlier today, the Supreme Court gave special counsel Jack Smith a deadline to reply to Trump, and it is an intriguing one. Next Tuesday at 4 p.m., 1 week from right now. If past is prologue, and given that every single day counts in terms of getting the federal election interference case back in the hands of Judge Tanya Chutkan and back on track to go to trial before the election, it's widely expected that special counsel Jack Smith and his team of pedal-to-the-metal prosecutors will act, and they will act fast. As the New York Times notes, quote, nothing prevents Mr. Smith from filing sooner, and he probably will. But what about the deadline itself, the one Chief Justice John Roberts gave Jack Smith? A whole week. As the New York Times points out, that timeline, quote, is not exactly speedy, a point that is particularly notable because, quote, the court often asks for quicker responses to emergency applications on what critics call its shadow docket. And as viewers of this show know well, quote, unless the justices move quickly, the trial could be pushed into the heart of the 2024 campaign or even past the election. And that is where we start today with Politico national correspondent Betsy Woodruff Swan, plus former U.S. attorney and co-host of the hashtag Sisters-in-Law podcast, Joyce Vance. And back with me at the table, MSNBC legal correspondent Lisa Rubin. Lisa, to say that time is of the essence here, a bit of an understatement. Your sense of when Jack Smith gets us
probably before the end of the week for a couple of reasons. Okay. One, the justices have a date on their calendar at the end of the week that's expressly marked off as a non-argument day and a conference day. That means that's going to be at the very least a day where the justices get together and talk about cases that they could hear or other pending applications. If you're Jack Smith, because a reply from Donald Trump is not called for here, you want to get that brief in potentially before that conference and allow the justices an opportunity to potentially act on Donald Trump's stay motion by the end of the week. That doesn't necessarily mean that they will, but that they could.
Well, you talked to me about what could happen. What else could happen? How could this play out once that's in?
They could order a reply brief from Trump, or Trump asks for a reply. They could take their time and wait until the deadline and then hold it over until they're ready to make a decision. You know, I looked at some past stay applications involving Donald Trump, and one of the analogs that I found is in the case where Trump was litigating with the January 6th committee over his assertion of executive privilege. That's a case where he both asked for the Supreme Court to do its review and asked for a stay pending their decision on certiorari simultaneously. So that makes it a little bit different than this. But in that case, those petition and the motion were filed on December 23rd, 2021. The court made its decision, I believe, a little bit less than a month later. So again, if that passed as prologue, even though there's a week deadline here, we could have an up or down answer on the stay itself within 3 to 4 weeks, even if, as in the executive privilege case I'm talking about, the court didn't decide the cert question until 4 weeks later.
Joyce, we're reading the tea leaves here because the tea leaves, they are all we have, as the New York Times and others have pointed out. In giving Jack Smith a deadline that is a week out, the Supreme Court is not setting a particularly speedy schedule. Should we read anything into that, Joyce, in terms of what this could mean for the timeline?
Well, look, as Lisa is pointing out, the procedural rules in the Supreme Court are always a little bit murky. And in fact, you know, we call the second brief, the brief the government will file here, a response brief, and then typically the party making the motion, here Trump, gets to file a reply. The Supreme Court rules don't explicitly provide for timing on that reply, but there is a memo that offers Trump the right to issue a reply brief here. And the court doesn't have to wait around for that to be filed before they vote on the case. They can actually ignore that reply brief if it doesn't come in before they go to conference. All that to say the procedural posture that the court is in right now is very arcane. And they can essentially decide this issue when they want to. They can decide to treat this motion, which is not, and I should say a petition rather than a motion because we're on appeal. They can treat the petition actually like a request from Trump to hear the substantive case, or they can take up only the issue of the continued stay of proceedings in the trial court. So tough to read these tea leaves, but I think it's safe to say that Jack Smith's team will act as quickly as they can here. They won't jump quickly just for the sake of going fast. It'll be more important to them to get it right than to get it fast. Trump raises a lot of arguments in his petition, but I think folks who have suggested that we'll see a response from this week are on target, and that would set the Supreme Court up to make its decision next week.
Betsy, let's talk about Trump saying he wants this case stayed pending both an en banc review by the entire D.C. Circuit Court and a Supreme Court review. The D.C. Circuit Court, they specifically waved Trump off from trying that. And yet here we are. You have Politico noting that, quote, such en banc rehearings are rare, but formal action on Trump's request for one could take weeks, particularly if any members of the appeals court wish to file an opinion or opinions disagreeing with their colleagues. I just wonder your sense of how likely the Supreme Court is to go along with this.
It's tough to say, and one thing perhaps that we can see from the particular set of tea leaves that we're looking at right now is that they're consistent with prior tea leaves from back in December when Jack Smith asked the Supreme Court to move very quickly on this immunity question, and the court declined to do so. One thing that Chief Justice Roberts has made clear is that he is not pedal to the metal when it comes to hashing out the legal issues related to this immunity question. He's not moving as fast as humanly possible. He's being more deliberative and moving more slowly than the Justice Department would like to see him do. That, of course, continues with this deadline that he's given Jack Smith in this particular case. The other piece of this that I think is important is that from Trump's perspective, getting an en banc review would be incredibly valuable because it's just a ton of judges that weigh in when it's every judge on a circuit involved. And that simply takes a long time. The joke is that for a group of judges that large to decide where to go to lunch could take weeks. Getting this many people all to just get their briefs, to get their filings put together, their rulings in a finite, reasonable amount of time would just be tough. So for Trump, that would be the jackpot. We'll see if he's able to get it.
Well, Lisa, you have the other Trump case that the Supreme Court is currently weighing, the 14th Amendment case. As you know, Judge Michael Luttig has been very vociferous on that case on this show in his writing, and he has now weighed in on presidential immunity, signing onto a brief that urges the court to deny Trump's presidential immunity application, arguing, quote, rejection of absolute immunity in this case is essential to protecting Article 2's design of the presidency itself. This court should deny a stay in this case because Mr. Trump's claim is of such a boundless immunity is wrong. One, it is interesting to me that Luttig, who's been so out there on 14th Amendment, there's almost some sense of saying, I listened to, I saw how it all went. We're now moving on to this question of presidential immunity. I do wonder, though, if you were a conservative justice, if having someone like Luttig, who's already weighed in on 14th Amendment, now weighing in on immunity carries any weight.
I think former Judge Luttig carries a lot of weight to a point. Yep. He has staked out a position with respect to Donald Trump's participation in the insurrection and what he considers unlawful conduct that goes back to the January 6th hearings. Given that, and given his transparent behind-the-scenes advising of former Vice President Trump, I don't know that his additional thumb on the scale here with respect to constitutional interpretation will make all that much more of a difference. On the other hand, is it important or valuable or it just causes a second reflection for some people, given how much distance Luttig, who was a legal giant of the right, has created between himself and the MAGA world? It's absolutely important. Elisa, I want to add something else about something that Betsy was saying, because when Jack Smith went before the Supreme Court initially to try and leapfrog the D.C. Circuit, he not only asked them to move with all deliberate speed. He used words like promptly and expeditious, but he asked them to review the case. And so in looking for his response, substantively, I think folks are really scratching their head. What does Jack Smith do now?
Right.
He has told the Supreme Court in no uncertain terms that it is of, and I'm quoting, imperative public importance that Trump's claims of immunity be resolved by this court. How he backs away from that now is hard to say. My guess is that he tries to split the baby with the bathwater, a la the solution that Andrew Weissman was floating on air with you yesterday, that he says the stay is not called for. You want to take the case? Take the case. It's important for the public to hear from the Supreme Court before there's a trial and possibly a conviction. But don't slow us down any further. We've already wasted 2 months since the time we filed this petition on December 11th.
Right.